quite a fair bit myself. And I've got a few things to do. Well, I'm just to let you know, I'm also fasting here right now. So I've got a few errands to run.
Okay.
So
See you.
thank you
Okay.
very much for having me, Vikram.
All right.
Great.
Nice. Pleasure
I
speaking to you,
really
Aziz.
enjoyed this
We'll see you.
session.
All right.
Fantastic.
Bye.
Bye-bye. Take care.
Bye. Yes, Guna, how are you?
I'm good, Vikram. Thank you.
Good. We gave Aziz 1 hour because I said let's have it was more of a general discussion. It was not didn't end up too much into the legislation. It was a more general discussion. So that's what it was. But thank you very much. It's been a long time. Haven't seen you.
Yep.
You don't become that busy traveling around the world. That's what you're
I'll be
doing.
seeing you soon in person. So
Yeah, good. That is a good part about your traveling, that you're coming here. But otherwise, so much of traveling that you're doing, we need you to create mediation circles.
I'm here. I'm always here. You know that.
Yeah. So okay, well, what we're doing, let's just put up what we're doing. So this is what we're doing: mediation, legislation, the how, what, when, where, which, who, why of it. And of course, Guna has lots of experience on this, so she definitely is going to come out with give us very major insights into the whole process of putting it up and all that. So Guna, I'll leave that to you, telling us about yourself, and then you'll give me that maybe 30 seconds to talk about my website and where to find information and what all is happening. Or maybe I'll ask you to tell us. Maybe let's see. Okay, please, Guna, about yourself.
Right. Since I've been on so many of your shows or symposiums, if I may reframe that. I just want to say that I've been a mediator for more than 30 years. So it's been some time, and I conduct a lot of mediation training. I know Vikram has his own views about training, but so do I. And I conduct mediation workshops. In fact, I have a few coming up along the way, mediation workshops for training the High Court judges and mediators. And it's been always an interesting journey when you talk about mediation. So I'm here today to share with all of you my views about mediation legislation, especially from the Malaysian perspective, and I'm going to tie it up with the Singapore Convention on Mediation and the model law, and touch on those areas as well. So, Vikram, back to you to share about your work, which you do. And as always, before I forget, thank you very much for having invited me for this symposium. And I really take my hats off to you, because you've spent so much of time, you have invested so much of energy in promoting mediation. And I think there's no one like you out there, Vikram.
Wow, thank you very much. You made my day, so now it's okay. So look, the thing is that, of course, new things keep happening. So this is the new thing that's happening. This is a new series, which you also will have to come on and talk about magic in mediation. We've had 2 episodes up till now. So Ken Cloak started the series. His book comes out by the end of the year on magic in mediation. So we've done that. Of course, connecting and all is there. World Mediation Circle, of course, that's something which now I felt that is what I should have focused on in April, but I had to have the symposium. It was on my mind for quite some time, so I said, let's do this. And of course, information is here. And of course, on the YouTube channel, there is a Gunavathi playlist of all the things that she's come on, so they can find information there. About the training part of it, what I am doing, Gunavathi, now is that a kind of a skill development program. So people from all over the world will have their sessions happening. So my issue with training part has always been that those people who have the mediator mindset, you can develop their skills. But to say that we will make mediators in a 40-hour factory, I have always had issues with that. So I said, we should, I keep criticizing something, but do I have an alternative? Am I giving an alternative? So we had started, you remember those lectures about mediation, which you also gave a lecture, that was going in a little unstructured way that anyone can come in, whatever they want to talk about. But now it'll be Gunavathi's whole sessions. And of course, they will have to make payments to you for those things. Yes, it's going to be on paid basis that they will do. How we work it out, do I get something out of it, not get something out of it, we'll see how it functions. But you have to be paid to do that. So we'll create that whole schedule there. And there should be enough of these happening from all parts of the world in every language, so that at least I can say that, look, I've identified those people with the mediator mindset, and they have these skill development programs available to them. So you don't have to go through this thing, oh, they have to go through this certification program and everything. The people, the user experience already there, skill development programs they have access to. So at least that kind of a whole structure is available. That's the thought. I'll go on. So, but Guna.
No, but just out of curiosity, Vikram, because I mean, you've always put it out there that people can pay something to your PayPal account and or contribute in some other way. Have people actually done it?
No, I know. I think over time I must have had maybe 10 people who would have done it, but I still have to keep putting it out there because for me it's a very major issue, because I keep talking to Ken about it also, that look, the mission and monetization, they can't be two different areas. So, and to merge the two, the biggest issue that comes up is restricting the audience. Because only if I put everything out on YouTube, then of course the people who watch it don't have to pay anything. And I felt to start with that if they're benefiting, why can't they send a gift? Did not happen. Then I said, okay. One person gave me a very interesting thing. They said, you keep saying you're a golfer. People think you have so much. Why do they need to give you anything? And if they don't know what to give you. I said, okay, then I put out a patrons. There's a patron page, on Patreon, there's a page. I put out there $9 a month. You can pay even that. If anything more than that is up to you. Nothing happened there also. But for me to actually move into that other aspect of it, like this training thing that I'm talking about, skill development part of it, I want people to have access to it from anywhere in the world. So I really don't want to say you pay X amount. I really want to leave it to them. But if they don't pay you a certain amount, that also won't be a good thing. So how do I balance that out is what I'm trying to figure out, because I don't want to put an X amount, because if that means it's going away from the concept that everyone doesn't have access, and I want everyone to have access. Yeah, we're going to take that call. That is a discussion we'll have, because we'll have to have it soon, because the World Mediators Conference is coming up, and during that conference I want all those sessions that we are going to do on skill development to have a short session on that, so people know the trainer. Let's call it trainer. They know the person. So Guna is going to be looking at these areas. We just to have those discussions in the conference.
Sure.
Thoughts. So Guna, mediation legislation.
Right, let's dive into it.
Yes.
As usual, I always prepare my slides. So
yes.
if I may share my screen, because I like something to be
on screen.
Structured. So,
okay.
You
like
so that I don't go all over the place. And because I know you said that, I should spend at least an hour. So I thought I should have something enough for an hour or less. Okay. Right. Very interesting topic which you've picked, Vikram. Mediation legislation, how, what, when, where, which, who, why. I mean, this is something which I use in my training. The what, when, how, why, which a mediator should ask, the kind of questions which a mediator should ask. Yeah. So the curiosity kills the cat. So, a mediator has to be curious by asking questions with what, when, how, why. I don't know whether that is why you termed this particular topic in that manner. Is that why?
Yeah, I feel that, look, if we don't question things, who else will?
True. Yeah. So that is why I thought, even someone like Vikram, who doesn't really believe in training, has come out with this. No, I'm just kidding, Vikram. Right.
Absolutely.
Okay. Let's start off this how. If I may just hang on. If I may just move on to slideshow. Yeah. Okay. Right. Okay. So when did it all start in Malaysia? So I'm going to speak about mediation legislation in Malaysia and how it all began. So initially, when the Malaysian lawyers were introduced to mediation, there was a lot of resistance. I think this happened in many other countries as well. The resistance from the bench and the bar. So we're talking about resistance from the judiciary as well as the lawyers. So the Bar Council was in the forefront, the Malaysian Bar Council, which is the Association for Lawyers in Malaysia. for my international friends who are listening from abroad. Yeah, so they set up, there was an initiative to set up the Malaysian Mediation Center. And it's now known as the Malaysian International Mediation Center. They recently changed their name as well. So initially when this thing was set up, the Malaysian Mediation Center was set up, I was one of the pioneer mediators in the country. So I assisted with the drawing up of the rules and the regulations, etc., for the setting up of the center itself. So when we started, of course, there were a group of us. We were all so excited about, in introducing mediation to the lawyers and the judiciary. And then we faced all this feedback from these lawyers who were, what is mediation? Why are you wasting our time? Let's just get on with it to court. I guess it's the same everywhere. But the judiciary at that time was also dealing with a huge backlog of cases. I think like in many other countries, how mediation actually took off, even in the United States, when it first took off by what Professor Frank Sanders said in the multi-door courthouse concept, that, because there was a backlog and that there was a need to actually introduce alternative ways to resolve a dispute. So this excitement was going on in 1998. And then we had our neighbors, Singapore, and thanks to them, they had already set up the Singapore Mediation Center. Of course, they're way ahead and they're very advanced. They're still way more advanced than Malaysia when it comes to mediation, definitely, and in many other ways as well, if I may say that. They came and offered to train a few of us, about 18 or 24 of us. This was the first batch where an introductory mediation course was offered by the Singapore Mediation Center, and they trained a few of us. And thereafter they had, it was an introduction course, so it was only like 2 days or 3 days, if I'm not mistaken. And thereafter they also conducted a second part to that course, which was more of the advanced course. And thereafter, we roped in the late Mr. David Newton, a very good friend of mine, who's an excellent mediator who has unfortunately passed on a few years ago. And he was with the Accord Group. The Accord Group is still operational, but David was one of the main players in the Accord Group. And David Newton came to Malaysia and he trained quite a number of us lawyers and also people from the Construction Industry Development Board, and also the Sharia courts, judges and judicial officers were trained by the late Mr. David Newton. So all this excitement was going on in 1998, 1999. The first batch of accredited mediators, including myself, we were all accredited and given certificates. So this created a lot of excitement in the bar, and many people were clamoring to become mediators because it's something new and something which I think they were all not familiar with. So word was out that training sessions were going to be conducted, etc. And so many of them tried to jump on board. Then when it came to the judiciary, the Chief Justice at that time was also seeing the way forward with mediation. And he personally came to hand our certificates to us, the first group of mediators. And he did say at that time that he will come up with a practice direction to assist lawyers to embrace mediation. So the practice direction did come out, but it wasn't immediate. I think it was like 2 years down the road after that, which everything then slowly started to fall into place. And the first set of mediation practice directions were issued by the Chief Justice at that time. And so slowly word started getting around and the practice directions were amended. Lawyers started getting trained. And so that is how it all began in 1998 onwards. Then the big question came about as to whether you need legislation. That's why I'm giving you a little background to this. So there was a big question mark as to whether you really need legislation for mediation, because mediation is supposed to be a voluntary and flexible process. So if it's a voluntary and flexible process, why do you need legislation to tell you what to do and what you're bound by, etc.? So there was a debate going on as to whether we should actually think of drawing up any legislation for mediation. And of course, then work started because the Chief Justice expressed his views that there should be some sort of legislation. So that is how the Mediation Act 2012 came about. So for many years, we were from 1999 onwards, there was discussion. So from, I think, year 2000, 2001, we started working on the Act. I say we because I was directly involved in coming up with some of the provisions of this Act, which of course is not what we thought it would be. I'll share my views on why I have my reservations about this Act. And after having worked on that Act with the Attorney General's Chambers Office, they invited people from all the stakeholders, actually, from different organizations, and everybody contributed. But unfortunately, at that time, many people didn't even know what mediation was all about. That was sad. So they couldn't really contribute as such, save for a few of us. So initially, when this Act was in a bill form, before it was passed, it was a much thicker Act. Now the Act has only 20 sections to it. And the Rules Committee for our civil procedure rules, we wanted to introduce mediation before this Act. We wanted to introduce mediation by way of amending the rules of court, our rules of court, to introduce mediation during the case management stage, or at that time it's known as summons for directions. That means once pleadings were closed, parties could then appear before the registrar or judge to seek directions or request for the matter to be mediated. So this was left to the parties, not participants. I heard what you were talking to Aziz earlier, but this was in court. So we're referring to parties here. So this went on for a while, and then the Bar Council actually, because I was in the committee at the time, and we were working very hard to push mediation forward. And unfortunately, we faced a lot of roadblocks, many roadblocks along the way. The rules were never amended to include mediation at that time. And then we started working on this draft. So I actually drafted the first draft on behalf of the Bar Council for the of this Act. It's nothing like what it appears now. And of course, the judiciary came up with their own version. They had their own version. And the Attorney General Chambers Office had their own version of the Act as well. So we all sat together, and this went on, believe me or not, for 10 years, Vikram. 10 years we worked on this. And finally, this Act came out with just 20 sections, 20 provisions, which was a far cry from what was originally drafted. And I think it's, of course, timely now for this Act to be amended. So let me just share with you all when this act came into force and some of the salient provisions of the act. So the act came into force on the 1st of August in 2012. And what happened was the object and purpose of the act was basically to encourage mediation as a method of ADR. And there was supposed to be facilitation, and the word here used is parties, Vikram, in the act. So we use, in Malaysia, we use the word parties in disputes, or sometimes what they refer to as disputants. But I would rather go with what you said, the word participants, but this is already in the act. So the idea was to encourage ADR to settle disputes in a fair, speedy, and cost-effective manner. And very interestingly, we have a definition of what is mediation. It's supposed to be voluntary. So that's why any proposal for any provisions which make it mandatory was removed from the act. And basically, the role of the mediator was to facilitate communication and negotiations to assist the parties in reaching an agreement to their dispute. So the mediator was not going to be the decision maker. Parties were going to decide their own outcome. And this basically was designed to, some of the elements here suggest that it is designed, or it was designed, to encompass the facilitative model of mediation, not the evaluative model, because of the voluntary nature and no imposition of solutions by the mediators. But there is a provision in the Act which provides that the mediator can suggest solutions, can suggest options for resolution. So this is the definition. And there is also a provision in the Act which specifically sets out the non-applicability of the Act to certain types of dispute. And this is provided for in the schedule, provisions of the Federal Constitution, prerogative writs, injunctive relief, election petitions, land acquisition proceedings, judicial review, appeals, revision, native court proceedings, and criminal matters. So all these were specifically excluded in the Mediation Act 2012. And along with that, the Act, which was initially, when we drafted it, it was supposed to have applied or applicable, or was supposed to be applicable to the judiciary as well. But then there was some resistance on that. And that is why there's also a provision in the Act which provides that mediation conducted by judges, magistrates, or judicial officers pursuant to proceedings in court are specifically excluded. So the Act doesn't apply to judges conducting mediation or mediators conducting mediation within the court system. And there is also another provision on mediation conducted by the legal aid department, which has also been excluded. This is basically the legal aid department in Malaysia. They conduct a mediation for family disputes, specifically for family disputes. So this has been excluded as well. So the Act doesn't really apply to all these people. Now, the definition of the who now, who can qualify to be a mediator? Well, I'm actually, if you ask me, I'm really not happy with this provision. I was actually quite shocked that they came up with this provision, because this provision was never drafted in this manner. And I think even the Singapore Convention on Mediation, they do not provide who a mediator should be. Here in this Act, it says is very vague, because Section 7 actually says that in the definition section of this Act, it says that you have to cross-refer to Section 7 of the Act for a definition of who can be a mediator. One is the person must possess relevant qualification, but it doesn't go further than that. So we really don't know what relevant qualification here means. So it's kept very open. I mean, there are pros and cons to keeping this open. And there's also a danger of people holding themselves out as mediators just to make a fast buck. So there is a danger, as I said, pros and cons when you talk about relevant qualification without actually qualifying what relevant qualification means. Then you have another category of persons who have special knowledge or experience in mediation. Again, this is also vague, and we don't really know what it means, people who have special knowledge or experience in mediation. And lastly would be people who satisfy the requirements of an institution. Here, institution would be professional institutions who conduct mediation, like the Malaysian International Mediation Center, the AIAC, the Arbitration International Center as well. They also have a mediation arm in the Arbitration Center. So they would fall under the third category. But the first two categories, it's vague. So this has, either you remove all of this, or you have a national, because in Malaysia, we do not have a national accreditation body. So when you talk about accreditation, I know we have had this conversation before, I think, about training and accreditation. When you talk about who can be a mediator, of course, people talk about competency and accreditation, etc. So in Malaysia, currently, there are different bodies giving accreditation certificates. There's no one national body regulating all these individual bodies giving out accreditation certificates. Like, I think in New Zealand, they have a national accreditation body. I think not many countries have. I don't know whether they have it in India. Do you all have a national?
Luckily, we have nothing like that.
Yeah, so there's nothing. Yeah, so in Malaysia, we don't have that as well. But as I said, there are pros and cons. Pros would be, of course, if it's regulated in a certain manner, then you know that the mediator who's going to mediate your dispute has some sort of expertise. Again, the cons would be, as I said, people trying to make a fast buck by holding themselves out as a mediator. So there are pros and cons to this. So that's my view. And moving on, we're talking about the provisions, about the Act in general. So the Act in general doesn't really say much. As I said, there are only 20 provisions. And firstly, there's no provisions to regulate practice of mediation in the country. No standards of competency have been set out. No accrediting authority. No mandatory mediation as well. As I said, it's all voluntary because the definition provision specifically states that it has to be voluntary. And no sanctions as well. No penalties for non-compliance with provisions of the Act. And of course, we can go on and discuss about whether there should be cost sanctions for people who breach the provisions of the Act. I mean, there's a lot of case law on this, but I don't want to go into that now. And of course, another provision which I want to draw your attention to is that there's no automatic stay of court proceedings. So like in the Arbitration Act in Malaysia, the Arbitration Act 2005 actually provides an automatic stay of proceedings if parties have commenced court proceedings and there is a provision in their relevant contracts providing for arbitration, for the dispute to be resolved by way of arbitration, then there is a stay of proceedings. It is provided for in the Act, but in the Mediation Act, there is no automatic stay. So assuming parties have a clause in their respective contracts for disputes to be resolved, firstly by way of mediation, before proceeding to file an action in court. But if it's ignored and parties file their action in court by just ignoring the provisions of in the agreement which provide for parties to try and resolve the dispute by way of mediation, there's no automatic stay. So court proceedings will be running parallel to any mediation proceedings which will take place or may not take place at all. Yeah. So that is one of the things which I would like to highlight. And next is the binding nature of the settlement agreement. So after parties have reached an agreement, they enter into a settlement agreement. The settlement agreement has to be written, like the Singapore Convention as well. It has to be written, it has to be witnessed by the mediator, and also signed by the parties, of course. And unfortunately, in this act, I know in India you have spoken about this, your Mediation, Conciliation and Arbitration Act has, you can enforce it in court. But in Malaysia, unfortunately, our Mediation Act does not have any such provision for it to be enforced or recorded as a consent judgment in court. However, if the mediation is conducted in court, then, no, if court proceedings have commenced, then parties can convert that settlement agreement into a consent judgment of the court. But it has to be all within the court system. So if it's outside, you can't then convert it. So for example, if I've started, I filed a suit in court and parties refer the matter to a private mediator outside and they reach settlement, that settlement agreement cannot be converted to a consent judgment in court because it was outside the realm of the courts. However, if the court, if it's conducted in the courts, and in Malaysia, if you conduct it in the courts, it's not conducted by a private mediator. It's conducted by court assisted or court annexed mediators. So that is the downside of this act. And initially, when I was involved in the drafting of this act, one of the provisions we looked at was the act in Philippines and Trinidad, where there are provisions in their domestic legislation for recording a consent judgment and to enforce a settlement agreement. So that was actually, I was actually very taken by that provision. So I made efforts to have that included in this act at that time. But unfortunately, it was shot down. So it was removed. But now, looking at the Singapore Convention on Mediation, obviously this has to be amended. Otherwise, we will never be able to ratify the convention. So I'll save that for later. But that is why, this act, some of us say that it's a toothless tiger, the act itself, because it has no oomph, if I may say so, because it lacks the effect of no sanctions, firstly, and secondly, not being able to enforce it like a consent judgment of the court. Because if you're going to enforce it like any other contract, you have to start from scratch again. You have to start by filing a suit, getting judgment, and then enforcing it. So it takes up a lot of time, wastes a lot of money. Yeah, the parties will end up paying more, and the costs, I mean, we have to take into account the cost element as well. So if you're going to enforce it like any other contract, then it really defeats the purpose of having the act in the first place.
But tell me, Guna, that the aspect that you are in a court, and of course you might have settled something outside, you can always, those terms of settlement, you can always get it recorded in the court and get a decree from the court on that basis, can't you?
But it was, if see this one, it says if proceedings are commenced in court. Of course, if parties agree to it, can. But we're talking about a settlement agreement pursuant to mediation.
Well, in that case, that mediation part of it becomes secondary. The first thing is they've settled the matter, and they can always tell the court that we settled the matter. Please pass the decree on the basis of our settlement.
Yeah, that's different. Yeah, if parties have commenced it in court and they go outside, you don't even have to talk about mediation. They go outside and they just have a cup of coffee and talk about it. They can record terms. Of course, there's nothing to stop them. But this, I'm talking about a private mediator conducting a mediation proceeding outside and then coming up with a settlement agreement and then having to enforce it again. Let's say no proceedings are in court. They say, okay, let's say it's a family dispute. Parties are fighting over a commercial transaction. So we enter into a settlement agreement. Nothing has been filed in court. That settlement agreement, if one party reneges on that contract, it cannot be enforced. You still have to go back to court to enforce it like a contract. So that's the downside of it.
That definitely needs to be provided for.
Yeah. So one good thing about the Act is that, of course, a mediator shall not be liable for any act or omission in respect of anything done while he's discharging his duty as a mediator. So this is a very good provision which we have in the Act, unless, of course, the act or omission is been proven to be fraudulent or involves willful misconduct. So other than that, that's the Act for you. You know, it's a very simple Act, as I said. But obviously, I will talk about the need to amend the Act later after I've spoken about the Singapore Convention on Mediation. Now, besides this particular piece of legislation in the country, there was a temporary piece of legislation which was promulgated, and it's called the COVID-19 Act for short. It is the temporary measures for reducing the impact of coronavirus disease. And this became operational on 11th November 2020 in the thick of COVID. And it has now ceased operations. And this was from the 23rd of October 2022. So when this act came into force, there were many businesses, small businesses, even large organizations who were suffering because of COVID, because they had to shut down their premises. They could not carry, like restaurants, they couldn't serve food. They had to shut down. And a lot of things happened, I suppose, not only in Malaysia, but all over the world. So the Malaysian government set up the COVID-19 Mediation Center to deal with disputes pursuant to this act. So any dispute in respect of the inability of any party to perform any contractual obligation, and there were certain categories of contracts specified in the Act, they could then resort to mediation. I'm speaking in the past tense because the Act doesn't apply anymore, and also the center has been shut down. But at that time, the Prime Minister's Department, this was set up by the Prime Minister's Department actually, and the functions of the center was to receive and process nationwide online applications for COVID-19 related mediation. And this, they did it in collaboration with appointed mediation service providers like the Bar Council, the Malaysian Mediation Center. So only a few of us were mediators. I was also a mediator in this COVID-19 mediation center. And many of the disputes were, it varied. It mostly were contractual disputes, landlord and tenant. And of course, payment of rentals were overdue, obligations under contracts to perform contractual obligations, different types, and also tourism disputes, where parties had paid to take up holiday packages and they couldn't continue with the package because of COVID. And there were also disputes like marriage, booking of function rooms, marriage halls. All this came under the the COVID-19 Mediation Center to resolve. And the disputes were valued at a sum not exceeding 500,000. So there was a limitation in respect of the amount, and it was given for free. This service was given for free for individuals under the lower income group and the middle income categories, as well as for micro enterprises and small and medium enterprises. So parties who are not eligible were also allowed to use the services of the center at a prescribed rate of 2,000 ringgit. So it was very helpful, I think, for parties who were really having a tough time during COVID. And also bankrupts or companies that have been wound up could also apply to the center with the approval of the Director of the Department of Insolvency. And the enforcement of these settlement agreements reached during COVID at the COVID-19 Mediation Center. The effect, of course, it's a binding contract, but again, if one party reneges on the contract, then you have to go back to court to enforce it, like how we enforce any other contract. Okay, so just some statistics. There were 290 cases referred to the center, and 79 of the cases were settled by mediation. So it was quite a good effort by the government to come up with this.
It could have been better. It could have been better.
Yeah, it could have been better. Yes, I mean, but it was a good effort by the government. But it's just that there were no takers, Vikram. It was very sad because I was involved in this from the beginning, from the outset. So it was very sad that there were not many takers, especially, people were still filing suits in court during COVID and refused to use mediation. So that is why, I mean, it's difficult to understand why there were no takers, especially when people were suffering, companies were suffering, people were suffering, yet there were no takers. It's a very, as you said, could have been a better.
Please get your students to work on this and find out what was the psychology behind these people who went to court.
It's very difficult to understand, Vikram, because they actually went all out to promote this. They went on the TV, on radios. They because at that time we couldn't travel, right? Because there was restrictions on travel. So they went on social media. They went all out to promote this, yet there were very few takers. So mediation has not really caught on in Malaysia. That's the next thing I want to talk about. It's sad. I mean, the act came into force in 2012, and then we go through COVID. We have this, yet people don't see it the way you and I do. The benefits of mediation, the benefits of actually mediating. And in fact, if I may just share a little story about one of the mediations, of course, it's confidential, but I can share what really happened. Of course, not going to name the parties, but very strangely, I did this landlord and tenant mediation during this COVID-19 and under the mediation, the Pusat Mediasi COVID-19, as we call it in Bahasa. There was the landlord, of course, the tenant was very unhappy with the landlord because the landlord refused to give any discounts on the rental, which were overdue during the COVID time. And this premises was in a mall. So because it was in a mall, the entire mall was shut down. There were no, you were not allowed to shop, right? Save for groceries. So only the grocery stores were open. This was a restaurant. So it was a Japanese restaurant. On top of that, they had to have fresh produce to sell their, to run their restaurant. So because of that, they had no choice but to shut their restaurant. And the mall knew about this. And the landlord knew about this and yet refused. And finally, after much, after the mediation, I couldn't settle this particular dispute because At the beginning, the landlord was very adamant. They refused to budge. They were very positional, if I may use mediation terminology here. They were very positional, and it was difficult for them to move from their position. They felt that it was their right to be entitled to this. So they were very positional. It was difficult to move them to see what were the interests of the tenant in not being able to run this place. They were out of money, and they were even willing to sell off some of their equipment, especially like refrigerators. And to sell Japanese food, you need proper refrigeration because of the fresh sashimi and sushi to make all these delicacies. And they were willing to actually sell off their refrigeration system, which was quite a bit. And they said that they could get some money to pay the landlord. But the landlord refused. The landlord refused. There were so many proposals put forward. There were so many options. Yet the landlord refused. So when we couldn't settle the first time round because it was free, the second, so we mediated the whole day, and it lasted for so many hours. I was really exhausted. And at the end of it, I said, okay, let's give it one more shot on a different day. And the center actually obliged and said that, yes, let's go a second round. And we went on for the second round. And to my horror, when they came for the second round of mediation, it was, we found out that they had actually gone, the landlord had taken out enforcement proceedings, they had taken judgment, they had actually gone ahead to enforce a writ of seizure and sale to try and seize the products, the equipment from the tenant. So it was really sad. And we can look at their mentality here. They've come for mediation, free mediation on top of that. Quietly behind the tenant's back, they've gone and done all this, taken judgment, and then tried to enforce it by writ of seizure and sale, and yet came for the mediation the second time round. So that says a lot, Vikram.
But Gunav, what about basically lawyers involved for sure? Majorly.
Yes, definitely. Lawyers were involved. That's a story for another day, Vikram.
But the important thing that came out from this, which people don't know, is that Guna is a big foodie. She knows that part came out very nicely from that.
Thank you, Vikram. Yes, but yeah, the sashimi and the sushi all have gone bad without the refrigeration system.
You felt bad about that. I think that's the worst that you felt about the food.
I know. So it was really sad because, as you said, why there were no takers. This is a very good example. They took it on, yet they went and did this behind the back and had the audacity to come for the mediation the second time round. So it's really sad.
Lawyers are doing that. The lawyers are doing that. The big thing. They're trying to create this front there, but at the back they're doing things which is really going against the basic concept. Because finally, look at the lawyer controlled thing will create a problem for mediation wherever in the world. It's not going to take off, and that won't be mediation by itself for me. But that's a story which will keep on. Yeah.
Yes, it's sad, but we have to deal with it. So that's the COVID Act for you. And
but one thing, you people were getting nothing out of it. It was totally free from the mediator's perspective also.
Oh no, mediator's perspective, we were paid. We were paid by the government. So it was really good because they actually made an effort, because they knew that we were making an effort. And there were only about 20 odd mediators specially empaneled on this to sit for this COVID-19 disputes. So it was quite good on the part of the government. I must say it was a very good effort by the government. Yeah. So the other places which conduct mediation, as I said, the Malaysian International Mediation Center, the Asian International Arbitration Center, the Securities Industry Dispute Resolution Center. Why I'm talking about these institutions are, they have their own, besides the legislation which I spoke about, the Mediation Act 2012, these professional institutions have their respective code of conduct. their own mediation rules as well. And of course, the Malaysian International Mediation Center has also entered into collaboration with many mediation centers in China and other countries to promote mediation. So MIMC is also a member of the Asian Mediation Association. I think India is also a member of the Asian Mediation Association. This was incorporated in 2007. And of course, we have the Hong Kong Mediation Center, Thai, Philippines, Fiji, and of course, Delhi, the Delhi Mediation Center, and many other centers, Indonesia, etc. So the Malaysian, then we also have the Malaysian China Business Mediation Center, which was set up jointly by the Malaysian Bar Council and the Mediation Center of the China Council for the Promotion of International Trade. So this is interesting because if you're talking about international trade here, then this is what is envisaged by the Singapore Convention, cross-border mediation disputes. And we also have a memorandum of understanding and cooperation signed with Beijing, with the China Chamber of International Commerce under the Belt and Road Initiative. So this was a development to strengthen infrastructure, trade, and investment links between China and 65 other countries over the Belt and Sea Road. Yeah. So this is a global cross-border project which we are involved in. And I think if the Singapore Convention is ratified, then this will be really useful for people using or businessmen who use this center. So which is known as the Malaysia-China Business Mediation Center. So coming up to AIAC, I mean, AIAC started off as an arbitration center in Malaysia. And of course, it's an international arbitration center. And now they also conduct domestic mediation and also international mediation. So they have their own rules as well. They have a definition of mediation here as well, which is similar to the one in the Mediation Act, voluntary, facilitating communication, etc. And a mediator has been defined in their rules as someone who's a neutral third party appointed or confirmed under the AIAC mediation rules. Now, of course, their fees are set, whereas in MIMC, the fees are not set. In AIAC, the fees are set. So the domestic mediator's fees is about 5,000 ringgit per day. And the international mediator's fees is about USD 6,000 per day. So they have their own rules. But what I would like to highlight here about mediation conducted in the AIAC is a provision which they have in their rules to conduct met-up. So because it's an arbitration center, I think they included met-up as one of their methods of resolving disputes. So as we all know, if it's met-up, you're going to start off with mediation, and then if mediation fails, to move to arbitration. And their mediated settlement agreement pursuant to met-up proceedings may be recorded as a consent award. And if it's an award, then we know it cannot be easily set aside, because it can only be set aside if there's fraud or omission on the part of the arbitrator or for fraudulent reasons. But other than that, it is not easy to set aside an award. So this is, I don't have any statistics on this. I don't know whether they have actually utilized met-up, because in the MIMC, we do not have such provisions. And similarly in SIDRAC, which is for the securities industry, they only have mediation. So AIAC is the only center providing met-up services. Okay, so they have their own rules.
But they're not talking. They're not talking about AAB med AAB.
No,
They're only
it's
talking
just
about
med up. It's not up med up. No.
Because AAB med AAB is, like I keep saying, that our act itself was so progressive enough to talk about it. In 1996, you were talking about AAB med AAB in the provisions of the act itself, that they can attempt to settle it by some other method like mediation. And then, of course, a consent award can be passed. And obviously, the enforceability, if people look at it from that perspective, although conciliation also gives the same route. So
True.
they could have stayed in the arbitration and got that. But at least we were talking about in 1996, and today that discussion is just about happening, it seems.
Yes.
So,
yeah. So, but I don't know whether if they amend the act, they might include it. We are still working on it. We haven't actually started work on that yet. And moving on, of course, we have court annexed mediation in the country. And as I said, there no legislation as such, but they have practice directions to govern what happens during court annexed mediation. You have it in the Sharia courts. I've spoken about this before when we were talking about community mediation, etc., where they have the practice of suluh, or what you call mediation. And of course, our civil courts as well. And the mediators in the Sharia courts are registrars and judges. They've actually been trained. Actually, the first few batches of the mediators were trained by the ACOT group from Australia, even the Sharia court judges. And in our civil courts, I have been the one training many of the judges and mediators there. But we have, so how this works is in the civil courts in Malaysia is we have mediation centers in all the different state courts. So if a judge wants to refer a dispute to the mediation center, he can do so, or he can conduct the mediation himself if the judge has been trained. But if the judge conducts the mediation and mediation fails for whatever reason, then the judge will have to transfer the file if it goes back to trial, to a different judge. So he won't be the same trial judge. But the problem is, if in smaller states, when you only have one high court judge, and he conducts the mediation, he will not be able to pass the file on to some other judge because he's the only one. So that's something which they need to work out as well. But most of the judges send their cases for mediation. It's referred to the respective mediation centers. And the mediation centers vary from state to state. Some of them have 4 mediators, some have 3. Of course, many of them are trained, but some of them then leave. And then you have new people there who are not trained. But of course, there's a big hue and cry about how they conduct mediation in these court centers, because are they really conducting mediation, or are they really, arm twisting parties to settle? So this has been a big hue and cry which has been going on. And in the Sharia courts, they send the lawyers out. Lawyers cannot even participate in the mediation sessions. Whereas in the civil courts, they claim that you can. And they have a very strange way of conducting mediation, if I may say that, because I've been on both sides. I have also represented clients during mediation in the courts. So I speak from my personal experience. They call the judge, the lawyers are called in first to meet the mediator to explain in a nutshell what the case is all about. The lawyers are sent out, and then the parties go in. I'm not saying participants here, parties here, because it's a court. Parties go in, and the lawyer is shut out. We really don't know what's going on inside. And suddenly, sometimes they come back and they say, oh, we have settled the matters. Oh, really? And sometimes it may be favorable to one person, not favorable to the other person. But when you talk about favorable, not favorable, I mean, when you're talking about mediation, fairness versus neutrality, that's another topic for another day.
You didn't participate in that. You should have participated in that symposium on neutrality and mediation.
Yeah, that's a very interesting topic, because what may be fair to me may not be fair to the mediator or to the parties. We really don't want to go into that now. So sorry for not participating in that Symposium.
But
So this is how it's conducted. So, sorry, Vikram, you're going to say something?
I want to understand the Sharia codes. Is there mediation in criminal matters?
No, only family disputes. Family disputes.
Is there a option that can be explored?
I think it can. So even in the civil courts, actually, when you talk about criminal matters, I remember very clearly how mediation was first used in criminal matters. If I may just share this, when I was teaching, my LLM students, and there was a case from Canada which actually started criminal mediation, and it's a very interesting case where in Canada, I don't know whether anyone from Canada has spoken, but this story is quite interesting because there was this old lady, I think her car, I think, two young boys, they sprayed graffiti on her car. And of course, she was upset, and the boys were caught, and they were all juveniles. So when the boys were caught, because they were minors, the sentencing, of course, would be different as they are all juveniles. And this old lady, they decided to go for mediation. And the mediator then, of course, brought the boys to the old lady, and the boys apologized for doing that. And what she wanted to know was, why did you do it to me? Why? So, why me? So I think the boys didn't have an explanation. They were just being naughty. And of course, that doesn't mean that they're going to get away scot-free just because they apologized to the lady. But that is how criminal mediation started, or what we call restorative justice, victim-offender mediation. So that is the criminal aspect of it. So, but in Malaysia, there was talk because, of course, in criminal courts, I don't do criminal work, but of course, in criminal courts, there's plea bargaining all the time. And they said that there was talk about extending it to the criminal courts. Because when you plea bargain, it is like what I explained just now, victim offender mediation. It doesn't mean that the criminal is going to get away, the accused person is going to get away scot-free, but it may go towards mitigation of his sentence if he meets the party, and also the effect of it on the victim if the person apologizes. So that's a very interesting topic, actually, victim offender mediation or restorative justice.
Yeah, because I was asking in terms of Sharia, because Sharia law at least takes care of this, that if the victim or the victim's family, at least in murder cases, victim's family agrees on something, that's it. You have to follow that. So
no. Criminal matters come within the jurisdiction of the courts. It's not by the Sharia courts. Sharia courts only deals with family disputes.
Okay.
So for murder and criminal, everything comes back to the civil courts.
But otherwise, you're not using Sharia law otherwise?
No, only in family disputes.
Okay, because I was thinking that in that sense, Sharia law and mediation can work together if this aspect is there in whichever country follows that if it's the victim or victim's family which decides whether they want to pursue it, and if you can actually work something out.
That apology and
whatever, yes. Whatever. So I think at least that option is in the Sharia law itself, that option is there. So mediation can be, so yeah.
But it's not practiced here.
Okay.
It's only for family disputes in the Sharia courts.
Oh.
Right. So I will move on quite quickly because it's already an hour, Vikram.
Not enough. I said R, but definitely R is also not enough with you. So, okay.
Yeah, so I'll just try and wrap this up. I just want to talk about the convention briefly. Of course, Malaysia is a signatory to the convention, and we have not ratified it yet, like India as well. So basically, of course, I think many of my colleagues who have spoken earlier may have spoken about the provisions. So I'm just going to go very quickly over this because I'm sure many of them would have spoken about the convention, right? The provisions of the convention.
I think you should know. I don't think I think you please take us through. You're the theory person. You have to take us through.
Okay, so basically, why was this set up? It was to resolve cross-border disputes through mediation for member states. So of course, you have to ratify the convention first. And the beauty of it is you don't have to rely on traditional courts to enforce the international mediated settlement agreements like a contract, like what needs to be done in our domestic scenario. So of course, if you're going to do this, there will be a huge savings in cost. And this will also be a harmonized regime to enforce mediated settlement outcomes throughout the world, actually. And member states to the convention will be perceived as a business-friendly nation. And this is, I think, crucial in attracting foreign investments to boost the economic growth of a particular state. And so far, I think 55 countries are signatories as of February 2023. 10 states have ratified as of September 2022. So still a long way to go for ratification.
Because 11th one came in, Uruguay came in March. So they've
Oh,
ratified in
sorry.
March. So,
So
for them,
11,
it'll be,
is it?
yeah, 11
okay.
now. Yeah.
So 11 now. So, but still a long way to go, Vikram. And the key aspects of, I will just touch on the key aspects of the convention. Now, the key aspects, the scope of application is clear here. It says that it gives very wide coverage for businesses because they will have greater assurance that mediation can be the effective method to resolve cross-border disputes. Okay. And it specifically says that it must be in writing and it must be in respect of a commercial dispute. So it actually excludes transactions relating to family, inheritance, and employment. And it also excludes settlement agreements enforceable as a court judgment or arbitral award. So it has to be strictly a mediated settlement agreement. And here, the definition of mediation, it says it's a process irrespective of the expression used or the basis upon which the process is carried out, whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third person or persons lacking the authority to impose a solution upon the parties. So now this is a very broad definition. And I think by this, the convention recognizes that mediation is a flexible process and encourages settlement on a without prejudice basis. So this, in my view, also like our Mediation Act, the definition seems to suggest that the mediation, the type of mediation which should be carried out is facilitative mediation and not evaluative mediation. Once again,
is it?
because
no,
you cannot impose a solution. I don't know. That's my view.
No, I am saying that this is one particular definition which is actually bringing all of them together when it says irrespective of the basis upon which the process is carried out.
Yes,
this is
but
what they're
about
trying
the
to
last
explain.
part? The lacking the authority to impose.
That is the concept of mediation itself. But this part, I felt this part was really important because everyone was trying to always, facilitative in one part of the world, the evaluative. So it says it doesn't matter. However the process is carried out, it doesn't matter. It's still mediation. Because this is something which we actually, I think we need to put out there, because that's what I've been trying to say, that the fact that you want to in some way put boxes on mediation itself in terms of the definition will create a problem. This has actually gone beyond that. I think that's really nice.
Yeah. So, but the fact remains that it should be voluntary and parties should decide for themselves. I think the most important thing is that it emphasizes that parties should reach their own solution. Yeah. Parties must make so that the jurisprudence behind mediation, which is party empowerment, is reinforced here, because mediators are not supposed to impose a solution. But what do you think of mediators suggesting solutions?
Perfectly all right. It has to be part of the, look, whatever broader definition, any definition you put, you need to put it out there, because otherwise what you're going to do is you create a situation when tomorrow someone says, oh, this was suggested by the mediator. So there's nothing wrong. The mediator can suggest, but this is the important part is,
I agree.
Did the mediator impose a solution on you? The
Yes.
imposition is the important word. There
Correct.
should be no imposition. But beyond that, to say that the suggestion won't happen, then you'll be creating an environment where so no one will be able to say anything. What is a suggestion by itself will become a disputed thing.
Correct. So I think a suggestion is fine, because sometimes when you're dealing with lay people, of course this is an international settlement, it's an international convention, so parties involved here won't be laymen. They will be people of businessmen and people of standing. So I think a suggestion is fine. I tend to agree with that as
And
well.
I think, and also I think, what we do is we sometimes think that the parties themselves, in this case, parties, I'm using the word, I should not be, participants, they're not intelligent enough. They're intelligent enough to understand when they want a suggestion, whether they're anyway even going to even hear your suggestion. They know everything. This is their process. They leave it to them. They'll understand the way they have to go about it. It'll go in the direction they want to take it. I think we sometimes feel that, oh no, we know better than them. They know and whom to listen to, what to listen to. It's finally, and whatever you might say, they know that yes, the solution they're going to reach on their own. No one is going to impose anything on them. They understand all that. It's not that. So we just sometimes think that they're not smart enough. It's their dispute. They're smarter than everyone else. They got into the dispute.
Yes, agreed. Right. So the other one is Article 4, which says that this is like it says reliance on evidence that the settlement agreement resulted from mediation, because they want to be absolutely sure that there was a mediation and it was signed as well. And very importantly, it also includes other form of evidence, which includes electronic communication. I think so it actually broadens the scope here. So it's really good that they have this. And this would be a catch-all provision actually. So it is really useful to enforce the result of a mediated settlement agreement. Of course, when you look at Article 5, these are the grounds of refusal to grant relief. And it actually sets out quite an exhaustive set of exceptions: incapacity for contractual reasons, subject matter not capable of settlement by mediation, and breach of mediator standards when we talk about impartiality.
This has to be debated also. Yeah.
Yes, this one.
Standard, because the word used is standards applicable to the mediator. I think that's what the language used there is.
Breach of mediator standards.
No, because the language that they used there was, I think.
If I may just, I have it here.
Yeah, it basically said the standards applicable to the mediator. Now, what are standards applicable to the mediator by itself will become a whole.
Yeah, because like if it's an institution, like as I was talking, like professional institutions conducting mediation, they have their own code of conduct and code of ethics, so you can go by that. But this one, there is no code of conduct or ethics, so this is very broad, very general in nature. So we may run into problems later on.
Exactly. Because I think the important thing is that, of course, the institutional aspect of it gets promoted, but whether that is something which is where work is happening, how much of it is happening needs to be looked at, because sometimes these provisions come in because those people influence these provisions when they are put out there. But when it comes to the practical part of it, do we really understand what has to be done? Because then they create another whole set of issues around it. What standard, this standard? There's so much happening on that end, which I have a problem with.
But this one, I think, is quite broadly. It says here there was a failure by the mediator to disclose to the parties circumstances that raise justifiable doubts as to the mediator's impartiality or independence. And such failure to disclose had a material impact or undue influence on a party, without which failure that party would have not entered into the settlement agreement. So this is really quite broad. So it can be challenged, I think.
These are going to be, but I think maybe we'll just say that this was a convention just to give people that basic thing that, okay, it's enforceable, it should not need to come into use. That's what
Let's hope so. Yeah. Let's hope so. Yes. Right. And lastly, I want to touch on the reservations, Article 8, where it says member states, there are two reservations basically. A member state may declare that the convention is inapplicable to the settlement agreement to which it is a party. And secondly, that it shall only apply according to the intent of the parties to the settlement agreement. So there's an opt-in regime here. So I don't know why this was included. I was listening to Delcy. I think she was one of the, she was involved in the drafting of this convention. And I really do not know why they have this second reservation. I mean, of course, it provides flexibility, but I don't know. You can also view it as ousting the applicability of the convention itself. So I can just opt in or opt out. So I don't know, because there is a principle under the Vienna Convention of the Law of Treaties that says that it's called the principle of pacta sunt servanda, which is enshrined in the Vienna Convention on the Law of Treaties, wherein it says parties are bound by the treaty in force and must perform its obligations in good faith. So if you have this opt-in reservation, I don't know whether it can be viewed as ousting the applicability of the convention. It's something to think about. I don't know whether others have spoken on this.
No one's spoken about the reservation part of it. And I don't know who has given the reservation. I think Georgia, Iran, and Kazakhstan have given that reservation, that it will be an opt-in kind of thing.
I see. Okay. Yeah. So it's interesting. So we'll just have to wait and see how this goes, but just my thoughts. And then the model law, of course, just want to touch very quickly on that. This is, of course,
what we might need to debate is why would people not want to opt in? That's what.
Exactly. Yeah.
Why would they not?
But I have to say that I was involved in discussions on this as well. You see, like in Singapore is different because Singapore has embraced the convention. They have, of course, ratified it. And they have the Singapore Convention on Mediation Act 2020. Yeah? And they also have the Supreme Court of Judicature Singapore Convention on Mediation Rules 2020. All this came about after because of the Singapore Convention on Mediation. So they have their legislation, their domestic legislation in place. Whereas Malaysia does not have any domestic legislation in place as yet to be able to ratify the convention. So a lot of work needs to be done to ratify the convention. So I was actually involved in the discussions to whether we should come up with a new act altogether before we ratify the convention, to come up with a new Mediation Act to replace this existing Mediation Act 2012, or should we amend the existing act to have a chapter on international mediated settlement agreements, because the current one is only for domestic. So there are various ways of doing it, but it all depends how the government how they want to take this and to what level they want to take this to. So in essence, I think
for me, the important part is that at least the discussion happens on ratification of the convention. At the same time, domestic legislation is looked at. And when domestic legislation is looked at, how simple can we make it is my focus.
Correct. Because if you make it too complicated, you see, if we try and amend the existing act, it's going to be quite difficult. Because firstly, here in the convention, it says that it can be enforceable. I mean, a mediated settlement agreement is enforceable in court. And our domestic legislation says otherwise. So we really have to go back.
Yeah, but then you'll have to, the option that you have is that one is that you can only make it enforceable for these international settlement agreements. So that you have an option of doing that. So that will be your ratification of the convention. But the point being that for domestic also, you should be looking at the same regime because it
Yes,
makes sense to you. It made sense to you.
correct.
And it's not just for ease of doing business that you're showing it. You actually understand the advantages of it. So that is why you should also do it for your domestic thing.
Yes. So we are actually moving towards that direction. And hopefully, but the only debate was whether we should create a new act altogether, like in Singapore, and follow the Singapore Convention on Mediation Act, which is easy because they then embrace the convention. And
but that is only, but that is only for the convention. They have their own settlement, that they have the
yes.
Mediation Act 2017 separately.
Yes.
So that is for the domestic legislation.
Yeah. So now they have the Singapore Convention on Mediation Act 2020. So
for the ratification there.
Yes, for the ratification purposes. So we could do that as well. So, but I seriously think that our current domestic mediation act needs to be amended as well. And as you said, I mean, if you're moving towards this direction, then why not have the same regime for both domestic and international?
And the interesting part that you can tell people is that if you don't do it, look, today the advantage is that you can actually, under the Singapore Convention, you can sign that or do that mediation anywhere in the world. And
Correct.
It is enforceable in a country which has ratified it. So if Malaysia has ratified it, the people who want enforceability will conduct it anywhere. They don't, in a settlement agreement, they don't even have to say where they conducted it. So in any case, will they be able to, I mean, certain things will anyway be enforceable that way. Why create this kind of thing in people's mind? Some things are, sometimes things are not. When, I mean, for what reason all these things are created? I don't know. I mean, but only thing of, yes, the parliament, does it have, are there vested interests on the other side? Is there a lobby of lawyers who do not want it done? All those issues, I think, become more of a debatable
Correct.
thing. So which we also don't know what influences there are to not get that legislation going.
Yeah, ours is going. We have started. So we've already had many discussions on this. But I'm not able to share what we have discussed.
What you have to take us through is that we have a model law which has been put out by UNCITRAL.
Correct.
From that perspective, from that part of it is important, that at least the direction has been given. What are the issues that you face there? What should be actually, what domestic legislation should look like? And this is not for only commercial. It can be for every domestic legislation. Has no limitation.
There's no restriction on the type of dispute. Because then it will apply to family disputes, employment, etc. Whereas the convention only applies to commercial disputes. So I think here in the model law, it says here, unless agreed, coming back to the met up thing, I just wanted to draw your attention to this. There's a provision in Article 13 where it says that unless agreed by parties, the mediator is not to act as an arbitrator. So this may have an effect on met up proceedings. So this is something which I don't know why.
But it's important because the point is that because the point is that if you're a mediator, you definitely should not be an arbitrator in that matter at all. I mean, that go totally against the concept, because either they're going to discuss every aspect with you, and then you're going to be deciding against them on that. Why will they even tell you anything?
Yes, because it goes against the rules of natural justice, if you ask me. Because when you talk about met up, I mean, during the mediation session, participants are going to talk to you in confidence. So there's a lot of confidential issues which may be shared with the mediator. And then when you convert it to an arbitration and you're wearing the hat of an arbitrator, you have already heard what was said in confidence. I mean, you can't just dissect that out from what you've heard and say, okay, I'm going to carry on as though I've never heard it. I think it's difficult.
So it's not possible.
Yeah, it's not possible. It's really not possible to do that.
But at least then look, at the end of the day, they've said, okay, if the parties agree, you can do anything you like because it's the parties' process. Okay, that option is given.
Yeah, I mean, if they want it, then it's okay.
Yeah.
So, well, that's a story for another day. Met up. Yeah.
Ab is the one that I think needs a lot of work. That is where things should happen. Lots of arbitration must be lying around or going through.
Yeah.
So I think that
True.
is where mediation, and then the fact that Singapore Convention not being so, I mean, popular right now, even for international disputes, that's recorded as a consent award, which can be enforced under the New York Convention. So for those people, let that be an avenue available for them for enforceability. So at least that mediation should carry on. It should not be that, oh, Singapore Convention is not popular, this, that, and the other. Those debates we don't want. No problem. It's not. Mediation you can use. Use it. Use the New York Convention. Not a problem. Use it. But at least use mediation and settle your dispute.
Correct. Yeah. Well, anyway, so coming to the model law, just before I wrap up, the arbitral and judicial proceedings undertaken by parties not to commence arbitral or judicial proceedings to be given effect. I mean, this is, I think, really good as well. Initiation of such proceedings are not to be regarded as a waiver of the agreement to mediate or as a termination of the mediation proceedings. I think this is a very good provision in the model law, which we can all look at as well when we are drafting our local legislation before we ratify the Singapore Convention. So in conclusion, I think our domestic legislation in Malaysia has to be amended before ratification to keep up with the regime, as we spoke about earlier. Question is whether we need a new Mediation Act or to amend the existing act to introduce a new chapter on the convention. Yeah. So that is all, Vikram. Thank you very much.
Thank you very much, Guna. I like the structured approach. I like the preparation that you do. But the only thing now you have to look at it from, you looked at the model law. Is that what you think legislation should look like? What was the basic idea of looking at the model law was that some people sat together. They said, okay, this seems to be what mediation legislation should look like. But do you see that as something that you think can be used in Malaysia? You would want to change it? What is that legislation that you would want in Malaysia?
I'm inclined towards the model law as well. I am. So we've had discussions, as I said, but I'm not able to share what was shared because it's supposed to be in confidence. I've sat in the committees and we have actually gone through each provision of the convention, and we have actually, there have been a lot of debates on what should be included, what shouldn't be included, whether we should opt in, whether, all these things were taken into account. But I am inclined towards the model law, and I think that very importantly, as you said, we must get mediation off the ground. And to do that, we must make sure that it's voluntary, to keep up with the jurisprudential part of what mediation is all about. Yeah, it's voluntary and allow that flexibility to people to decide their own disputes. Give them the power to decide their own disputes. Parties empowerment. That is very important. And then once they have been empowered to come to mediation and decide their own disputes, how they want it to be settled, then give effect to it. That's very important, because if one party then reneges on what they have agreed, then there's really no point. So the enforcement bit is also extremely important. And that's when the convention comes into play, model law comes into play, because they have provisions on enforceability of and the effect of the settlement agreement. I think people must be made to see that mediation is not the toothless tiger. It has the force of law. So that is why we need to embrace this openly, so that it will have the force of law. And hopefully once it has the force of law, parties will readily opt for mediation rather than run to the courts to resolve their disputes. That's my conclusion.
But Guna, now the thing is, at the other side, you have some powerful lobbies. One is the judiciary, the other is the lawyers, the third is these institutions which conduct mediations, fourth is the training institutions. So they will be lobbying to create a law in their favor. What are the things that they would want to put there, and why should they not be put there is also something which will come up in front of you as you go along, because this is something those people are waiting there to influence the legislation. So how would you look at them?
See, like the judiciary, I mean, I don't think they want to be involved in this, but there's no two ways about it. We have to amend. You see, when we embrace the Singapore Convention on Mediation, we have to amend the rules of court. We did speak about this because, and several other acts as well. Several other domestic legislation will also have to be amended if we are going to ratify the convention. And one of it is the rules of court, which the courts are bound by. And I think we need to include those clauses because we have reciprocal for enforcement of judgment provisions in the rules. But if we embrace the convention, we ratify the convention, and the rules are not amended accordingly to include these kind of mediated settlement agreements to be enforced in court, then once again, it's futile. So the judiciary must also embrace this. And I don't think there will be a problem. I don't see it as a huge problem because we have provisions in our rules to embrace the Arbitration Act, the awards. So what is so different here? I mean, if you can accept an arbitration award as yeah, and to enforce it, why not a mediated settlement agreement? That's my view. So let's hope so.
Yeah, and on a general level, in terms of domestic legislation, in general, of course, what is happening in the courts is happening. Would you want that to change and the courts not to be connected with mediation at all? Should the legislation be totally standalone and whoever wants to go in for mediation through that, or you are still looking at a structure where the court mandated aspect is going to be part of it? Because I'm going to take you through all these lobbies because each of them are going to influence legislation in every country. So let's just look at it from because it's their self-interest. Judiciary wants the backlog to go. So they will definitely want to be connected in some way. Can you look at backlog going away, but still not mediation being connected with the court system? Can this independent legislation just be available? Yes, they can go there if they want to mediate it. Can that be done, or we have to mandate the mediation?
You see, there was a big debate about whether we should mandate mediation because they said that our culture, I don't know, going back to culture again, I think it's interrelated about how people view mediation. For now, I think there are not many takers because people say, oh, what's the point of going for mediation even if I have a settlement agreement and I can't enforce it? I have to go to court again, sue the person once again. So you come back to the same, you come back to the same point where we started from. So when you talk about giving it some force and enforcing the settlement agreement in a court of law, then it's a different story. People may embrace mediation or look at mediation in a different way because if parties can resolve their disputes in a day with a mediator, right, by going for mediation and then enforce it in a court of law. I mean, why go through the whole rigmarole of filing the matter in court and going to court, etc.? But the other question which you posed a few questions earlier. The other question which you posed is, should there be a separate set of rules for the judges to mandate mediation and for lawyers to embrace mediation in court or outside the realm of the courts? That's a tough one, Vikram, because in Malaysia now, the statistics wise, the private mediation centers are not doing well because the courts have overtaken the process. So because everything is done in court, is free. Like even the other day, there was someone who approached me and said, oh, can you do a family mediation for me? I said, sure. I said, my first question is, have you filed it in court? So not yet. I said, oh, fantastic. let me mediate that first before it goes to court. Then he says, he didn't come back to me. And after 2 weeks, he came back to me and says, oh, no, they said that your mediator's fee is too expensive and they would rather go to court because in court it's free. So there you go.
But
so
I think you've hit the point. Let's just file a petition. Every country, the mediator should file a petition on discrimination. And of course, we are like, in terms of, we have our article about whether we are getting actually freedom to pursue our profession or occupation. We're not getting that freedom because you're giving it for free.
Yes.
So I think this by itself, every country we should file those petitions saying that this has to stop. You are actually, I mean, whatever, you're affecting our livelihood because we're practicing this and you're giving it for free. So I think that's just a good starting point that's come out from this symposium.
True. And we do try to impress upon people who come to us. We say that ours is actual mediation, whereas the court-conducted mediation, I mean, is a different form of mediation, right?
I don't call it mediation, but yeah, we'll have to call it mediation maybe, but
we have to call it mediation, but it's more of a settlement conference, if you ask me. I mean, for lack of a better word.
Yeah.
But they don't see it, they only think of it in terms of dollars and cents. Yeah. So there you go again. So
basically what we have to do is legislation has to make sure that there should be no concept of this free mediation part of it.
Yes.
It should go away. And if it's not, then there has to be challenged. I think discrimination is an easy thing to challenge it on. I think you people have to put it in. Okay, so that's from the look, this part of it needs to be debated, but it's going to be difficult only because the judiciary will make sure. But now look at the institutions. The institutions are doing mediations. In certain countries, they've been able to create legislation where matters in court before being taken up have to go through mediation in the institutions. Imagine that lobby, how huge that lobby will be, how much money is involved there.
Yes.
Would you be able to keep them away?
I don't think so.
Don't do that.
I don't think so. It's going to be tough. It's going to be tough, Vikram.
Seriously, that can take a totally different direction. Because,
yes, we really don't know. Well.
Then comes the next one. The other ones which I, of course, have an issue with is the training institutes, that if you can create a requirement for a certification and you are going to be, you have a body which regulates who's going to give that certification, major money involved, vested interests are going to come in. So are you going to be able to keep yourself away from that?
It's going to be really tough because, as you said, a lot of things to consider, a lot of money involved.
Yes.
And, different stakeholders, everybody will want to have a share in it, and everybody will want to have a say in it. And then you come back again. I don't know. I've mixed thoughts about, having a national regulatory body and not, because
just open doors for corruption. That's what you've
done. Yes, correct. I didn't want to say it, but you said it. I didn't want to say it. It's a huge door for corruption.
Absolutely. So
who can issue these certificates?
Exactly.
Whereas now it's kept open, so it's good in a way. So
for me, I'm saying that we have to be idealistic, and for me, that idealism is that the structure has to be so simple. Being the people's process, whoever they trust, they should be able to appoint. How can we restrict that? On what basis do we restrict that? And after that, the process totally flexible, the way it has to be conducted. It's the people in the mediation who take it. If they don't want someone to suggest, they will not ask them to suggest, and they will not take suggestions. So the process has to be, you can't start defining it, because the moment you start defining it, which was what Aziz was trying to show from the legislation in Singapore, all those things mentioned there doesn't seem like the way that you would want to put out to the process. Process is flexible, it can go wherever. Otherwise, seems that you have to do step 1, step 2, step 3 kind of thing. But beyond that, basics that need to be protected, that's all you need to do. I mean, I think that's how simple it needs to be.
Still a lot of work to be done here in Malaysia.
Vested interest, I'm telling you, that's going to be the biggest thing. And for me, first one is the judiciary. That part of it is the biggest. And of course, the lawyers, training institutions doing mediation. It's not easy to do that, but how much can you fight the system? We can keep putting out these.
Yeah.
So gonna your concluding remarks.
Well, I hope that Malaysia ratifies the convention soon. We have worked on the legislation. I hope we'll see the light at the end of the tunnel soon. And hopefully we move on, and more people are ready to embrace mediation. I mean, we've worked so hard from 1999 to now. It's very frustrating, Vikram, after putting in so much of work to promote mediation, to make people see the value in resolving their disputes amicably, and for them to be able to decide their own disputes, yet people not taking advantage of that and still wanting to use the court system to resolve their disputes. It's very disheartening. It can be very disheartening, very frustrating to see that, it's moving so slowly. So hopefully with the ratification of the convention, we will have, more people and businessmen especially embracing mediation and including, like on my part, like when we draft contracts, we always include a mediation clause before the other dispute resolution clauses, even if it's 2-prong or a 3-prong clause. I always include mediation as the first clause. So,
but this, we didn't discuss it with Aziz because, of course, we went into general discussion. But Singapore, one judgment has come out of Singapore on the clause part of it, and it doesn't seem to be a very reasonable decision, and goes against the whole concept of what you would want to put. They had given an option that, okay, they will try mediation, but it didn't seem from the clause that it also says that yes, otherwise they can use arbitration. But here that interpretation has been such, no, you have to use it. They're saying it wasn't worded that way. We didn't have to. We could have gone for arbitration. I mean, I don't have the judgment in front of me, but I'm just saying that sometimes it's not good for mediation to push people into mediation. So I think that will go against the clause itself, because they're trying to push you into mediation.
It depends on how the clause is worded, but of course, knowing the law, it's always open to interpretation.
No, it was very clear. If you read the judgment, if you read that clause. I
haven't read the judgment yet. Yeah, okay. I will look at it and read it. Yeah.
So sometimes I feel clauses, maybe for me, okay, it's a nice thing, but it's not something, because if you don't want to do it, you'll get out of it. If you want to do it, there should no clauses required. So I'm just saying that for me, it's the culture that needs to be developed. And for me, that word mediation circle and mediation circles that I want to create that culture with, legislation should not come in the way. That's my only first concern, because if you are going to limit who can do mediations, you actually, what I'm trying to do, identify those with the mediator mindset. If you said, oh, they can't mediate, or you're putting that, look, you won't be able to stop people from sitting with whoever they want to, but you'll put it in the countries where it's put in their mind, oh, they have to be registered somewhere on those kind of things. But if you look at the law, it's not required, but it's gone in people's mind. In the UK, people think they have to be registered with the CMC to be a mediator. No, there's no law doesn't require that. But it's been put into people's mind, oh, you have to get a mediator who's registered with the CMC. Those kind of things go into people's mind. So I want that this aspect of legislation should not affect people's mind, because you're just developing something and you've already put this class distinction. Oh, this person is not a mediator, that person is a mediator. So those are issues. But whatever, we do that, but we have to work on the ground in Malaysia. When are you going to? We have to find time. We'll take time from you, and we'll start discussing that. Yes. So thank you very much, Guna, and seeing you on 27th.
Yes, I will. Right. Thank you very much, Vikram, again for inviting me, and it was a pleasure as always having this discussion with you.
Yeah, no,
enjoyed it very much. Thank you very much.
Bye. Thanks.
Goodbye.